Okay, welcome back. Professor Mukesh Patel here. Let's talk about legal forms and agreements that all startup companies and small businesses need. And these are extremely important to have in place, but not just any form, having the right type of agreement in place with utilization of best practices. So, number one, you want to think about a confidentiality or a non disclosure agreement. This is also helpful if you have a patentable invention and you disclose that, let's say an investor pitch meeting, or if you're sharing it with other friends or colleagues, advisors, you want to make sure an NDA is in place to protect your proprietary rights, otherwise, and your intellectual property rights. Otherwise, the time within which you have to file for a patent could be triggered. Let's say it's 1 year. And so this will give you a little bit of protection on that. For investors, they typically do not sign NDAs. Even many advisors will not sign if they're professional advisors. Attorneys may not sign NDAs, although with legal counsel, you should be protected under the attorney-client privilege and confidentiality provisions. Investors might be willing to sign these when they get to the point of doing a technical due diligence on your company. So many investors will also say that if a company or prospect, a startup founder, asks them up front to sign an NDA, they might be turned off and might not be interested in investing because they cannot do it, and the founder should have done their own research and preparation to know that. So just be careful. Talk to your legal counsel about when it's appropriate or it's okay to proceed without an NDA. Leverage the legal counsel that you can get. So we talked about professional service providers like attorneys, tax attorneys, legal counsel. However, definitely try to get an NDA or a confidentiality agreement with vendors, strategic partners, joint ventures or alliances, and if possible, with employees, independent consultants, and contractors. Some of the considerations will be, should it be unilateral or should it be mutual? People or parties generally will be more agreeable and comfortable if it's a mutual NDA, meaning it applies to both sides. Who drafts it? The founders of the company. The company should try to draft it if possible, leveraging your legal counsel or legal resources. Talk to your attorney about having a clause that says that if there's a dispute, it will not be construed against the drafter if in fact you are the drafter. The reason there might be an advantage for your company to be the one that sends out the NDA as opposed to asking an employee or independent contractor or consultant or vendor, strategic partner to draft it is that the one who drafts it has a little bit more control on the language and a little bit more leverage, although it can be bilaterally or mutually negotiated. Try to keep it short and simple as opposed to lengthy and complex. Try to keep it as standard as possible, although there's no such thing as a form document. These are highly negotiated and can be different from one party to the next. So if you don't use an NDA for one reason or another, as advised by your counsel, an alternative that could be helpful is to speak and share your business idea in general terms without sharing your secret sauce. So basically talk about it at a high level. Don't go too much in detail about your proprietary business model or invention or secret sauce, and see if there's interest. And if there is, then later you can ask that party, before I divulge any more specific information or confidential information, we will need to have an NDA in place. What other documents are required? So if you have co-founders, you should have a co-founder agreement, which takes into consideration some of the key elements to prevent a dispute, or if you have a dispute, to prevent litigation by giving you a better alternative to amicably resolve your dispute. If you're a corporation, you will have articles of incorporation or certificate of incorporation. If you're a sub-S, you'll have that election form for a sub-S. And in either case, you should have bylaws and shareholder agreement and board resolutions. Those are critical corporate formation documents and governing documents. So make sure you have a reputable, experienced, qualified legal counsel or legal resource to help you with that. If you're an LLC, you'll have a certificate of formation and an operating agreement. And whether you're a corporation or LLC, you should have a distinct EIN, employer identification number, for your entity that's separate and distinct from your personal tax ID number or social security number, for example. This EIN will be needed to open up a commercial or business bank account and for other regulatory compliance matters as well. A few more documents to be thinking about. If you have employees, you'll have an employment agreement or an offer letter that might contain key provisions. If you have independent consultants or contractors, you should have an agreement with them. If you have advisors or a board of advisors, you might have an advisory board agreement, separate agreement for strategic partners, agreements with customers and vendors, and then of course there'll be many documents or investor agreements and documents, and then board documents as well. So we talked about many of these. This is just kind of saying internal agreements like co-founders agreement, operating agreement for an LLC, shareholder agreement and bylaws for a corporation, and then employment agreements or letters for employees. With any consultant or independent contractor that you have, make sure you have a consulting agreement that contains what's known as CIAA, Confidentiality and Invention and Assignment Agreement, as well as a work made for hire provision. That basically says that even if they're an independent contractor, all of the intellectual property rights belong to your company, and they are assigning those to your company. That's very important. Sometimes those provisions can also be in the advisory board agreements. External agreements will include things like term sheets and investor documents. A term sheet is typically given by an investor to the company that it seeks to make an investment in. As a company, you might have private policy terms or user terms and conditions for your website or mobile app. You might have disclaimers in your pitch deck, in your business plan, like confidentiality provisions, or even things like copyright insignia, trademark insignia, or things like that. When you sign any document, make sure you sign on behalf of your company and not individually. This is whether it's paper signatures or electronic signatures. Always list your company name. That's where you sign, print your name and your title. This way you do what's legally required to be done to maintain protection against unlimited liability or personal liability. If you sign individually and don't comply with the corporate requirements, that could pierce the corporate veil, as they say in law school, and open up the potential for legal liability against you personally. So stick to that. In the next module, we'll talk about the importance of securities laws and the conversation you should have with your attorneys on that.